Hi, everyone. I'm Tanya Rivero. The House Judiciary Committee has wrapped its first impeachment hearing, focusing on the constitutional grounds for impeachment. The hearing comes a day after the House Intelligence Committee, led by Democratic Chair Adam Schiff, released its report based on weeks of public and closed-door witness testimony. According to Schiff, the report concludes there was an overwhelming amount of evidence that President Trump sought to pressure Ukraine into announcing an investigation into Democratic presidential candidate Joe Biden. Today, the House Judiciary Committee heard from 4 constitutional scholars, 3 called by Democrats, 1 brought in by Republicans. The group faced questions about whether President Trump's actions meet the historical definition of impeachable offenses. For the 3 experts called by Democrats, the answer appeared to be yes. Take a listen.
President Trump's conduct, as described in the testimony and evidence, clearly constitutes impeachable high crimes and misdemeanors under the Constitution. The words abuse of office are not mystical or magical. They are very clear. The abuse of office occurs when the president uses a feature of his power, the awesome power of his office, not to serve the interests of the American public, but to serve his personal, individual, partisan electoral interests. That is what the evidence before the House indicates.
You know, a president who cared about the Constitution would say, Russia, if you're listening, butt out of our elections. And it shows a president who did this to strong-arm a foreign leader into smearing one of the president's opponents in our ongoing election season. That's not politics as usual, at least not in the United States or not in any mature democracy. It is instead a cardinal reason why the Constitution contains an impeachment power. Put simply, a president should resist foreign interference in our elections, not demand it and not welcome it. If we are to keep faith with our Constitution and with our republic, President Trump must be held to account.
After reviewing the evidence that's been made public, I cannot help but conclude that this president has attacked each of the Constitution's safeguards against establishing a monarchy in this country. If Congress fails to impeach here, then the impeachment process has lost all meaning. And along with that, our Constitution's carefully crafted safeguards against the establishment of a king on American soil. And therefore, I stand with the Constitution, and I stand with the framers who were committed to ensure that no one is above the law.
Meanwhile, the witness called by Republicans, George Washington University law professor Jonathan Turley, struck a different tone. He argued, even though he is not a supporter of President Trump, he believes House Democrats are moving through the process too quickly and have not established the evidence necessary to impeach. We should also note Turley is a paid CBS News legal contributor.
This would be the first impeachment in history where there would be considerable debate, and in my view, not compelling evidence of the commission of a crime. Second is the abbreviated period of this investigation, which is problematic and puzzling. This is a facially incomplete and inadequate record in order to impeach a president.
Joining me now to discuss are Major Garrett, Siobhan Hughes, Fin Gomez, and Rebecca Roiphe. Major is CBS News' chief Washington correspondent. Siobhan covers Congress for the Wall Street Journal. Fin Gomez is a CBS News White House producer. Rebecca is a CBSN legal contributor and former assistant district attorney in the New York County DA's office. Welcome to all of you. Major, what did we witness today?
Well, as you said, 4 witnesses, 3 invited by the Democrats, 1 by the Republicans. And in the morning, what we saw, as I said in our CBS News special report coverage, was an exact replication of our siloed American political conversation. The only difference, it was in a precisely constitutional construct. The 3 Democratic witnesses, only engaged with by Democrats, said there was clear evidence to them from their interpretation of the Constitution that all of these relevant issues, bribery, abuse of power, obstruction of justice, the evidentiary standard had been met, President Trump was guilty, and impeachment was the remedy. Then there was a Republican-called witness, Jonathan Turley, who happens to be one of our colleagues because he's a CBS News contributor. Talked only to the Republicans, said no, the evidentiary standard hadn't been met, that there was something risky and dangerous about so broadly applying these definitions in the Constitution of obstruction of justice, abuse of power, or high crimes and misdemeanors, that doing so rapidly would not only be injurious to this president and the historical understanding of impeachment, but in all future considerations of presidential conduct. So these are differing interpretations of the facts, the Constitution, and impeachment precedent. What I found striking, and this sort of replicated itself all day long, is that siloed conversation never got out of the partisan silos.
Yeah.
And that makes it, I think, extremely difficult for someone who, in a fair-minded way, is trying to figure out what the standards are, how they should be applied, and what the evidentiary basis for this crucial question. This is not an incidental question for the country. Will Donald Trump, the 45th President of the United States, be impeached, and should there be a trial to remove him from office? Nothing is bigger than that. And so if you're struggling to try to figure out what either the Constitution says, what our historical precedents are, what the evidentiary basis is, these siloed conversations provide, unless you're really, really devoted to them, less insight than I think a cross conversation might have provided.
So, Major, to drill into some of what you were just saying in his opening statement, Jonathan Turley wrote, quote, "The problem is that the House has not bothered to subpoena the key witnesses who would have such direct knowledge. This alone sets a dangerous precedent." But, Major, haven't several top staffers been subpoenaed only to have the White House instruct them not to cooperate? This did come up in the hearing, and this is the sticking point, I believe.
Yes, from the Democrats' point of view, this is one of the most important sticking points. Jonathan Turley raises an important point. Why are you moving so rapidly? Why won't you take this process through the courts? The Democratic response to that is, A, this is already running up against the 2020 election calendar. We're already accused of trying to interfere with that process by having an impeachment inquiry. We don't want to interfere any more than necessary. Plus, we also have an assertion without precedent from the executive branch that no one can or should testify, and that everyone the president identifies has something called testimonial immunity, cannot be compelled to talk to Congress about anything. And I'm not a constitutional law expert, I'm not a lawyer, but I've studied this issue not only in this case, but in the Clinton impeachment. Executive privilege is something that the executive branch can assert. A particular conversation, a particular document dealing with something sensitive to the presidency or its consideration of policy. Courts have recognized that. Congress have been rebuffed on that. That's something worth debating. But that's not what this White House is asserting. This White House is asserting testimonial immunity. Nothing can or should be disclosed. That's a new concept. Now, Jonathan Turley, if he were here, would say, then test that in court. Have the president lose on that, and then use that as evidence of obstructing justice. Don't jump ahead of that legal process. I think that is a fairly held point of view. And Democrats, I think, are going to have to explain why not wait and why not sort that out in the courts,
well,
even if it bumps into the 2020 election.
It is a fairly held point of view, Rebecca, but I want to turn to you on another sticking point with that argument, which is that, yes, Democrats could take the legal course and wait for all of this to run its course in the courts, but they are bumping up again, as Major just said, the 2020 election. And if part of what President Trump is being accused of doing is trying to manipulate the 2020 election in his favor, isn't that also then giving him more time to do that?
Right. I mean, one of the things that I thought was really good about the House's report is that the Mueller report doesn't really appear anywhere except for in the footnotes. And what it essentially is serving is saying, look, Mueller was out there testifying, and days later is exactly when all of this with the Ukraine started. So that what he's taking out of these proceedings is, I'm winning, it's okay, nobody's telling me I can't do this, I can continue to do this. So the Democrats' point here is, I think, if we don't do something now, he's going to continue to think that everybody thinks this is okay, so I can continue to do it. And I think that's the strongest argument, far better than, you know, any of the other arguments that they might have.
So what did you make of Turley's position that the Democrats would be in a much stronger place if they just let the subpoena, battle play itself out in court?
You know, I don't think anybody has any more patience for waiting to have this play out in court. I think that there's ample evidence already, and I think the evidence should speak for itself. And I also, the one thing that I thought was sort of not so well done today is that none of these experts, none of these law professors are any better than you and me at determining evidence and trying to figure out what you think actually happened. They should have simply been asked, if this is established, is that an impeachable offense? Instead, they got all muddied in what actually happened and do they believe what happened. I think if you look at Turley's testimony, one of the things that if I were a Democrat, I would be definitely focusing on is that he did not say, one, there was no quid pro quo and it didn't happen. He said, I need more evidence to try to figure out whether that happened. The second thing is he didn't say if that were established, it would not be an impeachable offense. In fact, he's written very clearly that he thinks it would be an impeachable offense. So that's the Republicans' expert who's saying those two things.
Right.
So I think that's significant. I only care about what their legal views are because that's the only thing that they have expertise on. They're not expert jurors.
So, Siobhan, Chairman Schiff has said that he's not going to let the White House play rope-a-dope for months in court. Do most Democrats feel that way?
Democrats, by and large, have lined up behind Adam Schiff. He got a standing ovation, apparently, at a closed-door House Democratic Caucus meeting this morning. Democrats say, as your analyst just said, they do have sufficient evidence to proceed, and it's really full steam ahead. One asterisk there at that closed-door meeting earlier this morning. The question was raised, why are we proceeding without hearing from John Bolton? That case could be resolved by the courts, but again, not likely in time before the House votes potentially on impeachment articles.
Now, Major Turley today said the modern definition of bribery does not lend itself to the current situation. He said, quote, President Trump can argue military and other aid is often used to influence other countries in taking domestic or international actions. He goes on to say, moreover, discussing visits to the White House is hardly the stuff of bribery under any of these common law sources. So is this similar? Does this strike you as similar to when Mick Mulvaney tells the briefing room that, you know, hey, there's political influence in politics and the press should just, quote, get over it?
The press should get over it, and the country should get over it, and Democrats should get over it. I think that was the acting chief of staff, Mick Mulvaney's actual declaration. Get over it. There is politics and foreign policy. Hello, that's absolutely true. And Jonathan Turley's point about the bribery standard in criminal case law at the federal level is well taken. And he has a Supreme Court decision on a recent case involving the former governor, Republican governor of Virginia, Bob McDonnell, where the Supreme Court said, though he was convicted, the standard applied for bribery was too broad. And to Jonathan Turley's point of view, that was a clearer case of bribery because actual gifts were received by Bob McDonnell and his wife, and even so, that conviction was overturned. Jonathan Turley looks at that and says, well, if actual things were received of value, and that wasn't bribery, how can these fact patterns be considered bribery? The other three constitutional law experts said, wait a minute, there is something of value in an investigation, even if it's just announced, about something implicating Joe Biden or his son. That has political value to the president. And there is something that is an official act, either a White House meeting or the resumption of congressionally appropriated military assistance to Ukraine. Those things are official acts and things of actual private, not national, not presidential value. There was a sharp disagreement about this, and it's replicated by the partisan voices you saw on the committee. Democrats look at that fact pattern and say, absolutely, that's an abuse of power at minimum. Some are prepared to call it bribery, but all are prepared to say it's improper, and to many of those Democrats who spoke to it directly, impeachable.
So, Rebecca, we also heard the witnesses describe why the framers of the Constitution chose to include an impeachment provision rather than let the misdeeds of a president simply be decided by the next election. How did they frame that?
Right. I mean, I think this is one of the best takeaways for the Democrats from today. I think they did a very good job of explaining why impeachment is valid, necessary, and what it was intended for, and that it was intended for conduct that if you view these facts as establishing, you know, this sort of quid pro quo, certainly definitely included that. The idea is the founders understood what incentives were and that somebody who is in power would have the incentive to keep that power at all costs. And one of those costs might be the very democratic institutions that got them into power. Right. So that's the key here. And I think that was the best takeaway for the Democrats. That was explained over and over again very clearly that this was the original meaning of both impeachment and bribery, treason, high crimes, and misdemeanors. This is exactly what it was meant to cover. And there was ample evidence of that. And I think the experts did a very good job of showing that.
Of explaining that. So, Fin, what are you hearing about how the president and his team are reacting to today's hearing?
I'm hearing a very uniform line from not only the White House, but the campaign. It started this morning with the president still at the NATO summit. He's on his way back, by the way, from London, but calling this a hoax. A few minutes ago, the vice president speaking in Michigan in his remarks also called it a sham, that the Congress should get back to their actual legislation and work instead of dealing with this. I just spoke to a senior White House official who is directly involved with the proceedings, and they said their message doesn't change. They say it's, quote, still a sham. It continues to be a sham. It's bipartisan. It's baseless. They point to the witnesses, the constitutional experts that the Democrats picked for the day, and said they call them all Democratic support donors at one point, that they're all biased in their interpretation in today's proceedings.
And so, Fin, a few members of the president's team, White House counsel Pat Cipollone and impeachment communications strategist Pam Bondi and Tony Sayegh, visited the Senate Republican Policy Lunch today. What do we know about why they were there?
In a word, strategy. But not only did it involve those three that you mentioned who are central at the White House's counter message, if you will, on impeachment, but also Eric Ueland, who is the senior White House director for legislative affairs, who also spoke to press afterwards, including our own Alan He, where he basically said this, that the White House, there are people within the White House, the top aides who believe that the impeachment ball is going to bounce into the court of the Senate, and they're preparing themselves for that. And also, it seems like he signaled today in comments to reporters that they're expecting a robust and aggressive reaction to, and they think they can get that fair sort of trial from a full trial in the Senate, along with live witnesses, something that was different from the impeachment trial of President Clinton. So they're looking for a robust reaction, it seems, and they're all focused on the Senate. The Senate, of course, being controlled by Republicans as well.
And Siobhan, speaking of the Senate, at this point, does it appear as though Senate Republicans are continuing to stand with the president?
Republicans are showing no signs of breaking with the president. That closed-door meeting today with Pat Cipollone, other members of the Trump team, and the Senate Republicans is no clear indication of that. We are told that, as your reporter just said, the White House wants the ability to call witnesses, to question witnesses. Mitch McConnell has indicated that he is willing to adopt procedures along party lines that would not include Democratic input in how to proceed. And so no sign of Senate Republicans breaking with Donald Trump.
All right. So, Rebecca, then, based on what we've heard today and in the report released Tuesday, what sort of impeachment charges could President Trump be faced with?
Well, it looks very much like we're moving in the direction of abuse of power instead of bribery, particularly. It looks like that's the way it's going to be laid out, and certainly an obstruction of Congress count as well.
All right. So, Major, the Judiciary Committee is considered one of the more partisan committees in the House. So how does that impact the course of the impeachment process, both today and going forward?
Well, the sad truth is this. Just about every committee in Congress now is regarded as more partisan than it used to be. It is true that the Judiciary Committee tends to attract members who want to deal with issues that have historically been partisan wedge issues: abortion, immigration, law and order. And that has given the committee a partisan cast before other committees were now viewed, as almost all of them are now, as more partisan than they used to be. But I think it's important what Fin just talked about in terms of the Senate trial. Having covered the Clinton impeachment, there is something distinctly different about the way this trial will be handled. Back when Bill Clinton's trial reached the Senate, there was a bipartisan agreement about how that Senate trial would be conducted for a couple of reasons. One, Senate Republicans did not have the stomach for a full-blown trial. They knew that they were not going to find the votes to remove Bill Clinton from office. They saw that Bill Clinton's popularity had made much of the idea of impeachment toxic, and they did not want to continue and prolong the toxicity of that impeachment process. So there was a bipartisan handshake to have a kind of pro forma trial in the Senate. The incentive pattern is now completely different for Senate Republicans and the White House. Having made all of these process arguments about unfairness, they do want a full-on, vigorous trial in the Senate because Republicans and this White House want to lean into the impeachment process because they don't believe it is costing the president politically. They believe it is not only rallying the base, but creating some sense of disquiet among independent voters. And they want to they feel it a political incentive to have a much more hard-fisted Senate trial where witnesses are questioned and the majority party, meaning the Senate Republicans, dictate much of the process, the witnesses called, and the questions asked and answered. So therein lies a distinct difference between the Clinton impeachment and the possible impeachment of President Trump, especially as it relates to a Senate trial.
All right. Siobhan, we've also been seeing reports, and as we discussed with Rebecca, that House Democrats are considering expanding the articles of impeachment beyond Ukraine, including obstruction of justice. What are you hearing about this, and is there a chance that that could happen?
The hearing today indicated that there was a clear chance. That came up when the Democrats' counsel, Norm Eisen, asked the University of North Carolina law professor if he saw any indication to support obstruction of justice. And Michael Gerhardt, the University of North Carolina professor, said, yes, you need to look no further than the Mueller report. The Mueller report, of course, had nothing to do with Ukraine. It covered obstruction of justice by the president when the president sought to have Special Counsel Robert Mueller removed. And so it's clear that House Judiciary, at least, is looking into expanding articles of impeachment beyond Ukraine.
Major Garrett, Siobhan Hughes, Fin Gomez, and Rebecca Roiphe, thank you so much.